Good morning. Bill Henry, Robinson Henry, Colorado State Planning Attorney. Today I want to talk to you about inherited IRAs and a question that's come up on whether or not those assets are protected from creditors. So specifically what we're talking about is if you have an IRA and upon your death, the beneficiaries listed are your spouse or your children, are those assets protected? Well, let's talk about the children. There was a specific case in 2014. It was Clark v. Romaker. And in that case, there was a woman, and her name was Ruth. And Ruth, during her life, had set up an IRA, and she had accumulated a significant amount of assets in that. Then upon her passing, those assets went to her daughter, Heidi. Well, Heidi was not quite as fiscally responsible and ultimately ended up filing a bankruptcy. And the assets at the time that when she filed bankruptcy in the IRA were $300,000, so quite a lot of money. And so the question was whether or not those assets could be attached by the bankruptcy court to pay off her creditors. The case went all the way up to the Supreme Court of the United States, and the Supreme Court unanimously held that yes, those assets could be used to pay off her creditors. They were not protected. They were not exempt property in a bankruptcy court. Most certainly not the result that Heidi wanted, and my guess is not the result that Ruth wanted either. So let's go through various scenarios and determine whether or not IRA assets are generally protected, inherited IRA assets are generally protected. Well, first, let's talk about you and your IRA. The answer is yes, that those assets are protected from your creditors in most circumstances. Your children, on the other hand, just like we saw, the answer is no. Inherited IRA assets are not protected. We can go on to your spouse. Your spouse, believe it or not, is yes, generally protected. So if your spouse inherits an IRA, those assets are generally protected. Your grandchildren, just like your kids, your children, is not protected. Likewise, if you give your money to a friend, once again, not protected. What can we do about it? Well, one option that you could look at is what's called a standalone retirement trust. In a standalone retirement trust, we have our person, and during their life, they are contributing funds to the IRA over time. Now, upon their death, instead of giving the money directly to their children, or if they leave their spouse as the primary beneficiary, then the secondary beneficiary, instead of leaving it directly to their children, what they can do is they can leave it to a trust. That trust says to pay their children, but nobody else. So no one else can get the funds if it's drafted properly. So therefore, if a creditor comes along, or mean creditor comes along trying to get to the funds, so let's say the child started a business and the business failed, the child was a spendthrift, had a bunch of credit card debt, whatever the reason is, no, those assets cannot be attached and done properly, can't be attached in the bankruptcy court either. Warning. Big warning on these is that they must be drafted very carefully. There can be large tax consequences that cost you and your beneficiaries a lot of money if they're not done properly. So you can force what's called a 5-year payout. We want to avoid that. So probably not something you want to download from the internet. Make sure whoever you work with knows what they're doing with retirement trusts. And good luck. If you have any questions, feel free to reach out to me. Either at our website, robinsonhenry.com, or on our Facebook channel, which is facebook.com/groups/Colorado Estate Planning.